You're listening to the Valley Current.
Hi, Jack.
Raphael, how have you been?
I'm fine. How are you?
I'm excited because this is a topic that I've been thinking about for a while, and you sent me an article that seems to reflect a lot of the same thinking that we've shared over the period. And just for the sake of the listeners, there's an oral argument that's set for tomorrow in Washington, D.C. before the U.S. Supreme Court in a case involving a photograph of Prince, but I guess he had to change his name, right? Didn't he have to change his name because of some trademark dispute to the performer previously known as Prince or something like that? There's some backstory to that.
I didn't read that part, but yeah, the photographer took a photo of Prince, and then Warhol doctored it supposedly. And the question is, did he make fair use of it?
Right. I think he agrees. I think everyone agrees that the photograph was the base instrument or the base material. It's not like there's any confusion about that. They admit. And the question is the work of Warhol so, quote, transformative that it effectively creates a fair use of the underlying material in a way that no longer requires any derivative work license fee or royalty or payment for the new work that was created as a result of the manipulation of the previous work. I don't think.
And since the previous work is a photograph of Prince, she didn't invent Prince.
Right.
So it's a photograph.
Right.
I also kept asking myself while I was reading about this, how was she harmed?
Well, she didn't get the royalty that she expected, and she somehow feels as though her work in taking the photograph was taken unfair advantage of by a famous guy who did add some bit of value, but in her mind, his bit of value doesn't amount to anything that should deny her a royalty. And, the interesting part of it is it probably wouldn't have been that big of a royalty. Now, maybe it would have been in absolute dollars, enough to fight over. But clearly, this fight has taken on a legend of litigation. I mean, a legion of litigation all the way to the U.S. Supreme Court.
She did get her royalty from Vogue, wasn't it? The magazine. She got paid in 1984.
Right.
She made a deal. She gave them a license. It was limited use.
Right.
And she got paid for that. Yeah. So how was she hurt? What really did she expect to get more than that payment from Vogue?
Because she would argue that the license was limited to that single use.
Correct.
It didn't go beyond that. And that whatever is then done thereafter by whoever does it, whether it's the magazine or someone on behalf of the magazine or Warhol, they have to pay a new license fee. That effectively there's a new obligation that arises from a new use. And that new use was essentially what was created with the colors. I mean, I don't know how the Supreme Court argues these cases without allowing people to bring in some of the visual materials, because there is sort of a bit of a judgment call that's being asked to be made about what actually was transformed. Like what actually occurred here that was so transformative that it created a new work. The way you might say a parody leverages off of an old work, but it does create kind of a jousting new type of work that's different from and transformative to the previous work.
Well, the parody, this could be interpreted as a parody of the photograph or a parody of the face. And I don't think that parodies have to be transformative. They just have to take a different point of view and present it.
Right.
So, to me, I've never been a fan of Warhol's work in the first place, and I don't find this very profound or meaningful or any way contributing anything. However, I understand her feeling, but let me go back to my point. she makes a deal in 1984.
Right.
She gets paid.
Right.
She probably has no legitimate expectation of being able to sell this photograph again or elsewhere.
Well, it
I
wasn't.
didn't read any testimony about she expected to sell it.
Right. I mean, it wasn't sold, it was licensed. So she still owns the underlying copyright, which, we're going to put this up on the screen just for the advantage of,
right,
if we can show it. I mean, on the left of looking on the screen is the actual black and white photograph. And it is of a guy who must have given his permission to allow taking the photograph, right? He was the performer.
He did.
Right? Called Prince. Right. And I think he had to change his name to eventually formally known as Prince because it was a trademark issue, but that's a separate dispute for a separate discussion.
Right.
And what Warhol did was take just his face, so cropped it to take out the shirt, and I guess there's suspenders there or something.
Right.
Suspenders and maybe a tie or something.
Right.
A white shirt. And just cropped it and then maybe use some sort of computer application of the color orange and blue, because I guess his hair turns blue at the borders if you really look carefully. And
emphasize the lines around the eyes and the eyebrows.
Right.
And the mustache.
Right.
And under the lip.
Right.
He did a lot of editing.
Right. And he creates then you could say a different aesthetic or a different look. Maybe there's a gentler look in the photograph and a harsher look in the actual parody, if you want to call it a parody of the photograph, if that's the argument that's made. And usually parodies are viewed as transformative. I mean, we're using shorthand here because ultimately a district judge decided that there was a fair use. And it's the Second Circuit Court of Appeal that reversed, saying, no, this was not transformative or not sufficiently transformative. And it still more or less is the same photograph. Now, it's not exactly the same, but at least the facial image is clearly adapted from or derivative to the underlying photograph. And then you get to this question of, well, what actually happened here and how do you judge it? And who should judge it? Is it a jury question or is it a judge question?
Let me back up one other hypothetical question. Mm-hmm. Suppose Warhol had called Prince up and said, come to my studio, I'm going to do a portrait of you. And did exactly this, because it's the same face after all. Would that be an infringement of copyright?
No, you can go even further. And Warhol says, I really want you to look the way you looked when that photograph was previously taken, that black and white photograph. So let's do your hair up the same way. Let's get the same shirt. The law in that area is the photo taking of the subject will own the photographer clicking that camera will own the new copyright that arises from that new photo, even if it more or less was aligned to look like the previous photo. So it's like a new copyright exists, but it's more or less the same image. But the view is it arises from the taking of the creation of the new image that was mocked up the same way. I don't think it would be viewed as an infringement because it's not a copy of the copy. It's a copy of the original.
Right. Exactly. So if the thing that she had created were an original work of art, and Warhol took that original work of art and painted it orange, that's a different case from this, because Prince has a certain face, and it's a fact. It's like the Golden Gate Bridge. I can take a photo, you can take a photo.
Right.
They look alike.
Leaning Tower of Pisa is very common. These monuments, the Notre Dame Cathedral, there's these famous places that people are taking photos of all the time. And yeah, there's a copyright there, but you could argue it's a pretty thin copyright because I think where you're hinting at is it's sort of like copywriting facts a very
Right.
thin copyright. It's the arrangement of the facts. It's not any underlying claim to a monopoly on any particular fact.
Or face.
The fact, right?
Or face.
Or a face, right?
Right.
A fact is a fact, a face is a face. And, there is a California state law that protects the person's image, the face, for example, from effectively an invasion of privacy or an exploitation. But here, consent, there's no dispute that consent was given by Prince for the original photograph. And
Right.
Prince gave up, I guess, his right to claim, sure, you could take my picture, but I think we should co-own the copyright. You should account to me for profits and all this other stuff that could have been negotiated. Apparently he didn't do that. He has since died, is my recollection of the story, right? He had like an overdose and
Yes, he died. He died, and that was after his death. Warhol did this portfolio, including many people like
Right.
Prince.
Right. I mean, I wonder if it wasn't a famous person like Warhol, where his name really injects a whole new aspect to the case, because he's such a famous guy and he's got such a big following that almost anything he does can be argued to be transformative, even if it's like an image of Campbell's soup or Brillo scouring pads.
Right.
He's done those
Right.
works as well.
Well, the Campbell soup was one of his early things.
Right.
And, there are several aspects to this. His painting does not infringe the market of Campbell soup at all.
Right.
And in this case, I don't think his painting infringes the market that this photographer had,
Right.
if he had one.
Right. It's interesting because there are people that think that maybe there's fair use in one context, but not fair use in a different context. There's somebody that's tried to argue that, well, maybe the fair use factors need to be broadened to look at, well, is there actually some competition here? And maybe the answer is yes, if it's going into a gallery or going into a museum where they're going to be side by side, but no, if it's in a different distribution chain. And some people have said, that would allow much more open usage. Because remember, I think this is all commercial, right? Everyone's trying to make money here. This is a commercial use, right?
Appears to be. By the way, one of the, to me, missing elements of the copyright law, I think Warhol should have put, based on Goldsmith, was Goldsmith her name?
Yes.
Based on the Goldsmith photo.
Right.
Attribution. As long as there's attribution, I don't think she has anything to complain about.
Oh, so
particularly,
there should be a footnote or something right there, which is based on the original photograph.
Right. Particularly if they're side by side in a museum, she would be happy to be side by side. And if he acknowledged her as the source, she has nothing to complain about. It's not an infringement of copyright. But copyright law doesn't seem to require attribution and doesn't seem to reward attribution.
Yeah, it's different than, say, the laws in France or Europe, where there's.
So I understand.
Where there's this notion of there really needs to be attribution, because otherwise you are stealing some goodwill that should be allocated to the prior author.
Yes.
A little bit like the plagiarism rules in graduate school, where you really do have to cite to the source
that
you're using. You can't claim to be the original idea person if you're leveraging off of a source.
Except most scholarly books begin by saying, I got these ideas from Freud, from Jung, and I cite you to the books in my bibliography, and it's from those writings that I've developed this. Everything we do in our intellectual creative world is based on something else that somebody else did.
In most cases, for sure.
In most cases, yeah.
I mean, probably 99% of the cases. I mean, an electric car wasn't created by Elon Musk or Tesla. There was an original electric car, I think, that dates back to like the 1800s, but that obviously didn't have charging stations located everywhere and all of the stuff that Tesla added, and computerization and mapping and so many other things that were added to the story over time that really created a certain uniqueness in what Tesla delivered from an inventive point of view. I mean, the part I sort of look at when I look at a case like this is when you get these close questions, if you say, well, maybe there's a close question because obviously you've got 4 different judges below, 1 in the district court, 3 in the Court of Appeal that differ. And now it goes up to 9 justices on the U.S. Supreme Court. You know they're going to look at the photo. You know it was in the brief. You know it was in the record. And it's pretty much all focused on this side-by-side that we have up. And, you know, they're making a judgment call about a lot of things that really don't necessarily scream an answer one way or the other, at least in my mind. I could see this case going either way, and I could see different jurors deciding this case differently based on how they feel about the work that was done and who did it, because there might have been arguably more work done by Warhol in the transformation than the clicking of the original picture that she took, right?
Absolutely. So one of the things I've been thinking about is no matter how the Supreme Court decides this, will we get a set of clearer rules about what constitutes fair use? I don't think so. I think every fair use case requires the side-by-side and a judgment call.
Right. I mean, it's very factual. The prior fair use case was a Google case involving Oracle and software code. I mean, that's like almost at the other end of the spectrum. That's really aesthetic. I mean, this is almost at the very end of how do you judge the aesthetics of what is clearly a derivative? I think everyone's going to say, yes, it's a derivative, but it's a transformative derivative that takes on new life independent of the underlying work, almost like saying what Warhol created was far more valuable in the overall scheme of things. Or
simply had a different value. And by the way, the copyright statute says derivative work includes transformed works.
Right.
The copyright law is very confused in this area.
Right. It's confused because it's trying to make sure that someone that doesn't make an identical copy, but makes something that's a close copy or a derivative copy, because the idea, look, if this was a stick figure of him that anyone could just put on a board, we wouldn't be saying anything other than it's just an extension of the idea of a guy with a mustache, right? But it's clearly the underlying work that was transformed or adapted was that photograph. It was recropped. There was some shading put in, some other stuff done, as you noted previously. And it does create this new image. And then the question is, you know, you could argue it's a procedural question. Who makes the decision? Because we leave these hard decisions often to juries on the view that juries are not bogged down by a lot of law and by what might be argued to be a judicial bias in whatever bias the particular judge happens to have. And, you know, there's even an argument that there's a circuit split. I don't know if that's really true, but there's an argument that the Ninth Circuit is going one way and the Second Circuit is going another way. That is, the Ninth Circuit would find fair use, whereas the Second Circuit won't find fair use, almost like saying there's more fair use potential in the Hollywood industries in the Ninth Circuit versus in what might be called the more commercial industries in the Second Circuit, which is New York and the East Coast states. So I don't know if that's true, because I always thought it went the other way. I always thought copyright was more broadly protective in the Ninth Circuit because of the entertainment industry and not this fair use going the other way. But that's what's being suggested, that there's a split in the circuits, which is one of the reasons the U.S. Supreme Court takes a case like this, because usually they're not just trying to judge an individual case. They're trying to come out with a highly organized set of principles about how do cases like this get decided. Because,
like Roe v. Wade, right?
Yeah, I mean,
a set of principles.
Right. I mean, even though subject to criticism, there was a lot of interesting reasoning in that case about how do we decide to reverse? What are the ways when we're reversing precedent? What are the ways we look at what's actually happened over time? And so it's not like the Supreme Court fails to understand their mission. I just wonder, when they took this case, what were they thinking they were going to accomplish? Because they knew they had decided that Google versus Oracle case, and they must have felt like this is somehow going to create a bookend of some sort to that case. And the question is, what sort of bookend do they have in mind? To go in a direction that says this is not fair use, whereas the Google versus Oracle case, there was some finding of fair use in that case. Is that where they want to go with this? I mean, they could have let the Second Circuit decision stand and wait to see what else played out in this area of visual arts. But it's hard to read. I mean, it's hard for me to read. It's hard for me to understand what they actually want to accomplish with this case, other than perhaps saying these are decisions that are more fact-based and judges shouldn't make them. There should have been a trial. Could be. The trial should be 6, 7, 8, 9 jurors, depending on the number of alternates above the typical 6 in federal court in a civil case. Right. And therefore, the jury is what's going to decide this. An unanimous federal jury will make the right decision more often than not. And this is a much more factually bound question than a legal question subject to summary judgment rulings.
I agree.
Now, the flip side is, if you say there's going to be a lot more derivative works generated by automation, as we were mentioning in the previous discussion we had, and other people are commenting on, such as these AI tools, is this a good thing to have juries, a lot of jury trials to decide these cases? Because a jury trial is a very expensive process that most federal judges don't frankly like. I mean, not that they dislike juries, but they don't like the burden. If every case has to go to trial and every copyright case has to go to trial, if there's a fair use defense, that's a lot of trials. And they can't make these summary judgment rulings as often.
Right. I agree. I mean, I think the law is a little bit of a mess. If this photographer had come to me and said, would you please take this case? I would have said no. I would have said no. You know, I said, you're not suffering any harm. There's no revenue that would have come to you. You haven't had a single license fee since 1984. And he did something original. It may not be very impressive, but all you did was take a picture of a man. So I would have told the client, don't do it. But obviously somebody said she should do it.
Right. I mean, you might have said, where my head was going as you were saying those various points, is look, he didn't take the whole photograph. About half of the photograph is left out. I mean, if you measure the photograph in inches, about 50% of it is out. I mean, the whole bottom half of it is out. And you could argue that he took Warhol took the most important part, because it's what people focus on, the facial image, but he didn't take the entirety of the work. He didn't knock it off, as one would say. He did. Yeah,
but on that point, the law is, did he use a substantial portion?
Right.
And I think the answer here is yes.
Yeah, you would say, if you want to decompose it, had he just used the hairline
Correct.
left out the face and put some happy face in the middle. That
Or a
would have
can of Campbell's soup.
Yeah,
under
that
the
would have
hair.
been that would have been a bit of a parody of, hey, his
Right.
hair is on top of a can of Campbell's soup or is on top of a yellow smiley face. But
Right.
it doesn't really necessarily capture her entire image in any real way.
Right.
Or flip it the other way, if he had just taken maybe the mustache and left out, or just the eyes and left out the hair and left out the nose and the
Right.
lower portion, you would get to the same sort of view that, look, it really wasn't a knockoff. It wasn't really a substantial enough copy. No one's going to think you were the author. So it goes back to your point. Some people may well think you're the author of this, but Warhol is claiming to be the author of something that you're not listed on. And you should have been viewed somehow as almost like a co-author. But for co-authorship, you have to have an intention. The two co-authors have to have an intention of combining their material and ideas and expression together, not this derivative work aspect where previous work is merely derived by
Right.
someone else with no real communication with the prior author as to how things should change or be updated.
Right. Right. I feel that attribution would solve a lot of moral problems, but whether they would solve the problems you and I are talking about, I doubt.
Right. Yeah, I mean, it's an interesting question of if you had to get to a creative solution, which of course these cases beg for often, if they're going to avoid expensive litigation, you probably would have added that attribution point for sure on a going forward basis. And then you probably would have added some idea of some royalty, maybe up to some ceiling that says Warhol is really the guy who's driving this. It's his name. It's his notoriety. You were relatively unknown to the art community. Your work was not necessarily even a piece of art. What he's created is actually, you could argue, is a non-photograph piece of art. It's not really a photograph anymore. It's much more like his own piece of art, where you could say, by analogy, well, let's say he actually painted this from looking at her photograph, but he actually put all this into brush strokes in the way he did it. Would that be considered more transformative because he didn't use whatever computer automation was used to create what's here as the orange image on the right side of the screen?
Right.
I don't know. So we're going to hear oral argument. The oral arguments are now available in real time, audio, even though the Supreme Court has reopened. So the physical court is now accepting advocates again in the courthouse itself. I think some people wear masks, some people don't. That's an interesting question. They don't allow cameras still in the courthouse, but they do allow audio. And the audio is transmitted as it has been during the 2.5 years of the pandemic. And so you could listen in to the argument. And I wonder, at the end of the day, these people must be working so hard tonight to refine their argument. They must be spending so much time for what amounts to maybe a half hour each in total time. And maybe a few minutes by the Solicitor General was invited to argue. And there's a woman that's going to argue for the solicitor.
Right.
You have to wonder how many hours of preparation they each must be doing in their respective offices or homes or over the last week or two or months, and whether there was some new insight that came across as a result. Like, what would Mel Nimmer, my mentor at UCLA Law School when I was there, he was the guy, he was the king of copyright. His treatise with his son, Nimmer and Nimmer, is still the treatise, Nimmer and Nimmer on copyright. Previously was just Nimmer on copyright. I mean, I wonder what Mel would say about this, because he often had really interesting insights about how cases should be decided. And he often disagreed with the way in which lots of decisions made their way into the books. And he would read just about every case of any importance, and certainly every U.S. Supreme Court case. And I wonder if he were still alive, what his amicus brief would look like, because I'm sure he'd be interested in this question. And I'm sure there would be a group of people that would want his name on what to do, because he really is the expert in that area. And his son is certainly an expert as well. He now works at Irell and Manella in Los Angeles. I've had him on the podcast. He's a really bright guy. And, you know, I don't think he has weighed in on any amicus filing, at least as best I can tell. But, you know, these amicus filings, they all are going down different roads in terms of how courts should look at fair use, because fair use does open the door to others being able to jockey an advantage of somebody else's work in a legal way. And it's not like it's easy to figure out ahead of time whether it's going to work or not. It's not like the Copyright Office gives an opinion or there's some administrative agency that does. Essentially, you wait for whoever the decision maker is in the district court, whether it's a judge or jury, to make that decision, and then what happens on appeal. So It's been a long road, I'm sure, for the owner of the photograph, Miss Goldsmith. I'm sure it's been a long, long road for her.
Sure.
In terms of the original filing, because this case, I think, was filed, well, the appeal, I think, was 2020. So that's a couple of years ago. The district court proceedings are probably back in 2018.
17 or 18, I think. Yeah.
So you're looking at 4, 5, 6 years of litigation. And if the Supreme Court reverses, I guess the Second Circuit must have remanded the case for a trial on the question of, well, what's the appropriate remedies if there's no fair use? What's the right royalty? What are the damages? Is there going to be attorney's fees? Because that's the other thing that copyright cases afford. If people have registered their copyright in advance of the infringement,
right,
the prevailing plaintiff gets attorney's fees. That can be a pretty sizable bill.
Correct.
For the Warhol Foundation, which is a nonprofit at this point, to have to pay. You know, similarly, the defendant can win prevailing party legal fees if the Second Circuit is upheld. That could be a pretty big bill that she would have to pay.
Yeah, she'd have to sell her camera.
Well, you know, think about it. I mean, maybe that's not really bearing on anyone's mind, but it's not trivial.
You're right. You're right. Let's listen. I can't listen to the argument live, but I think I'll listen to the recordings.
Yeah, I think we should listen. I think we should listen and come back and do another session on what insights we get from the way the argument goes down, and more importantly, the way the questions are pitched. You know, we don't have Justice Breyer anymore. Justice Breyer would often have very, very pragmatic questions about how is this going to work? What's the effect on the burdens of the court? Who makes the decision? You know, what's a question of fact? What's a question of law? What's a mixed question of fact and law? And who can make that decision? So we don't have him because he retired, and we have a brand new justice.
She seems good so far.
Right. So it'll be interesting to see whether, you know, this is going to be viewed as an easy case and they give it to the most junior justice, or whether this is considered a hard case, in which case I don't know who would get the lead decision. If you say it's mostly a conservative court, you probably would predict that the court would be leaning against fair use and in support of the Second Circuit's decision on the view that someone who created a work should get paid and anyone else should have to pay, and the payment should be made, and these cases should sort of stay out of court. I mean, that's one conservative view that you could try to assign to the conservative group of justices, but maybe the flip side is there's more of a view that fair use should be more open game, because a lot of these works are pretty thin in terms of copyright protection to begin with.
Right.
Just a photograph of an existing person that has an existing, or previously existing person that has a set of facial features that are well known.
Right. Right.
I mean, the
That's
only
what
way,
we see.
yeah, the only way to make this more complicated, I think, is if you said the picture was of Warhol himself, and
Right.
Warhol himself gave the consent, and Warhol gave his foundation all of his image rights, all of his residual image rights. And the question is, how dare you sue the foundation, the nonprofit foundation of the very person who gave you consent, because obviously it was his face to begin with that
Right.
gave you the consent. So you shouldn't be taking unfair advantage of him, because if he were still alive, he'd be livid that you're somehow
Right.
challenging what he did with his own image of himself.
Right.
I mean,
Right.
that's the only way this would be more profound. And I bet we'll see one of the justices come up with that hypothetical. Like, would it change at all if it was Warhol's face? I'll make that prediction for you, and we'll see if I'm even half right or close to being right.
We won't see an opinion for a few months, will we?
No, but just the commentary often is a good signal of where they're headed with things,
Right.
and whether they think that there's a way to think about this that will set up essentially a way for judges to reason around these cases. I mean, if they want to be very narrow, I think they focus just on photographs as opposed to the more generic question of copyrighted works,
Right.
which could be anything, soft
Right.
code, anything that represents expression.
Right. Right.
So,
Let's
anyway,
wait and see.
thank you very much for coming on. I think it's a very interesting case, and one of the ones that we're going to see likely have some impact going forward in how the federal courts handle copyright fair use cases, particularly in the visual arts, but maybe even
Right.
more generally.
Right.
So thank you for coming on. We'll get together again. I'll look forward to listening with you and see where this goes with the argument that's set for tomorrow.
Let's do.
You
Have a
take
good
care.
evening.
You too.
See you.
Take care. Bye-bye.
Bye.
Tune in next time on The Valley Current.